What is the elective share for a surviving spouse? Have you ever wondered what happens to a spouse's inheritance when their partner passes away? The elective share is a key concept in estate planning that ensures a surviving spouse receives a fair portion of the deceased spouse's estate, no matter what the will states. This legal provision is designed to protect the surviving spouse from being completely disinherited or receiving an unfairly small inheritance. The elective share is established by state law, so the specifics can vary depending on where you live. Essentially, it allows the surviving spouse to claim a fixed fraction or percentage of the deceased spouse's estate. This right overrides any will provisions that might attempt to reduce the spouse's inheritance below a certain amount. Now, how much is this elective share? That can differ quite a bit from state to state. For instance, in South Carolina, the elective share is set at 1/3 of the deceased spouse's probate estate. Meanwhile, in Florida, the surviving spouse is entitled to 30% of the deceased spouse's elective estate. This term includes more than just the probate estate. It also covers certain non-probate assets, which can be quite beneficial for the surviving spouse. When calculating the elective share, it's important to understand the difference between the elective estate and the probate estate. The elective share is often based on the elective estate, which includes the probate estate plus additional assets like jointly held property, revocable trusts, and retirement accounts. This broader definition helps ensure that the surviving spouse is adequately protected. To claim the elective share, the surviving spouse must act quickly and follow the specific procedures outlined by state law. If they miss the deadline or fail to file the necessary paperwork, they could lose this important right. Additionally, it's possible for the elective share to be waived. This usually happens through a written agreement, like a prenuptial or postnuptial agreement, signed by both spouses. The right to an elective share generally applies as long as the marriage was legally intact at the time of the deceased spouse's death. This means that even if the couple was separated but not divorced, the surviving spouse may still be entitled to claim this share. Understanding the elective share is vital for anyone involved in estate planning. It helps ensure that spousal rights are respected and can prevent disputes or unintended disinheritance. Couples often consider estate planning tools, such as prenuptial agreements or trusts, to manage or waive these rights when appropriate. For surviving spouses, knowing about the elective share can be essential for securing their financial interests after the loss of their partner.